Good morning. Can everybody hear me?
Good morning, Justice Black. We can hear you.
Okay, thank you. Who is representing whom, please?
So we have HFW for the respondent, and Mr. Nick Baganza is representing them. For the claimant, we have Mr. Sean Morgan from Franklin Morgan Legal Advisory.
Thank you very much.
And we also have Mr. Thani Al-Falasi.
Yes, Mr. Al-Flassi is a witness, I think. So, I have had a look at the papers. So, Mr. Morgan, this is your application. Sorry, you haven't frozen. You're just being very still.
Sorry, Your Honor.
Yes, and this is your application, actually without notice to be dealt with on the papers. I've read the papers, and first of all, I can't see any urgency. Second of all, I can't see at the moment why it should be without notice. And thirdly, I have some difficulty following the papers anyway. I can't track, for example, how the 83.5 million is calculated. So those are giving me some problems. You're very welcome to address those matters. I just have a couple of background questions. Mr. Braganza, it said your clients are evading service. Have you accepted service or not?
The court will be aware that we acknowledge service.
You have acknowledged service,
we have
you?
acknowledged service, yes.
And what
exactly.
date was that?
We acknowledged service on the, sorry, bear with me, 6th of October.
6th of October, you acknowledged service. Okay.
But we reserve our position on service.
I know about that, and I know you say you have a jurisdictional challenge.
Yes.
Okay.
And we'll be challenging service in that same application.
Yes, I see that. So, Mr. Morgan, you're quite welcome to try and persuade me that I shouldn't give directions for this to be an inter-parties hearing and for the finding of evidence by the defendant in reply. We can have the hearing quite quickly, but you're quite welcome to try and persuade me that I should deal with this today as a matter of urgency, and that I find all the material that I need. And because I've only had the papers, actually I got them on an aeroplane last night, but I have read them. So what do you wish to do? Are you content either that we get this up and running as a proper contested claim? I'll come to Part 8. I don't think it's a Part 8 claim anyway, given allegations of forgery, amongst other things. And it seems there are some seriously contested issues. So, I mean, my inclination would be that this continues as a Part 7 claim, and if you're to proceed with your injunction, we can fix a hearing and we can fix a time for evidence and for you to file evidence in reply. So what do you say to all that?
Well, I thank you, Your Honor. I can concur with what you say. This whole situation has been brought about by the defendant's actions. We never sought in our preliminary claim any type of injunctive relief. It was based on the defendant's actions, which then necessitated further submissions to the court. As Your Honor has quite rightly said, the defendant evaded service.
No, I said it was alleged they were evading service.
Sorry.
Don't put words in my mouth.
I apologize, Your Honor. So the alleged evading of service by simply going and issuing a police complaint in the local police station, as opposed to accepting service, which for us was quite vexatious, because the actual practitioner is registered in the DIFC courts. So they would be very much aware that acceptance of service or acknowledgement of service would in no way prejudice their position, even now with the esteemed Mr. Braganza wishing to challenge jurisdiction or the deficiency of service. So this whole status now has been brought about by the defendants. I also agree that there is no urgency, but the underlying claim is one that's quite serious and puzzling, whereby the defendants, as lawyers, legal consultants, legal counsel, have received from the Dubai Execution Court more than 85 million dirhams. That can't be in dispute. This is clear and concise factual evidence. And we only inquired at the beginning, with the greatest respect to the defendants, what did you do with this money? If you haven't given it to the claimant, your client, then please provide an accounting. No response. Okay, if you don't wish to provide a response, then we will have to take the necessary claims before the court. And now there's a concern that the defendant, the respondents, are aware that they are holding 85 million dirhams of the claimant's money. And now the claimant has a serious interest to have this money at least held or frozen pending the outcome of a fully fledged contested claim or case. Our position is the same. Yes, we're happy to set aside or to withdraw our injunction request or freezing order, but we would hope that the court may consider the order whereby the respondent is required to provide an accounting, as should any law firm do for their client, as to what they've done with this money.
No, I understand entirely your position, and that comes across from the documents. Procedurally, I think the issue for you is, do you wish to proceed with an injunction on a contested basis? Because there are obviously other serious issues, such as jurisdiction, and I don't know what, obviously, they're going to say about the money and the agreement that they had with your clients. So when you say you're happy to withdraw the injunction, I don't get a sense that you are. It sounds to me as if you want to proceed with an injunction, but on a contested basis, pending the defense and the challenge to jurisdiction. And what it appears to me is the best way forward is for me to make directions today for that hearing to take place in fairly short order, and to give Mr. Braganza's client the opportunity to file evidence in response to your application, and for you to reply to that, and then we get a hearing on.
Very much, sir. Yes, procedurally, I agree, Your Honor.
Okay, well, that being so, Mr. Braganza, the issue is, how long do you need?
Well, the questions about service and jurisdiction need to be determined first, in my view.
No, they don't. They don't when it comes to the question of the injunction. The injunction, they can apply for an injunction before those issues are determined, and obviously the criteria are different. They have to show a risk of dissipation, and they have to show a good arguable case. All of the freezing injunction criteria, but we don't have to decide the substantive defense, which is going to take a long time. So I'm minded to hear an injunction application ASAP, but to give you the chance to put evidence in reply and to do it on notice inter partes.
I appreciate that. Yes, I accept, of course, that there are reasons for granting the injunction outside these questions being dealt with. I think all that Mr. Morgan has alleged is that the reasons behind his injunction application are the fact that my clients allegedly were evading service, and that's prompted, and that's the basis on which.
Well, he's not just said that, but
well, in his application, it's hard to see that there is any other justification for such. He hasn't gone through any of the tests that you briefly outlined, such as.
Well, I'm not going to preempt any finding that I make.
No.
The issue, each party will file such evidence as it thinks is appropriate, and I will reach a conclusion on that evidence. All I'm concerned about now is the procedural aspects and getting this on. So I come back to the very simple question: how long do you want?
Yes, sure. We will be filing our jurisdiction challenge on Friday. So I guess if the court is happy for these to be running in parallel, we're happy with that as well. I guess we still haven't been served with any application. You'll appreciate we found out about it through access to the court portal, but no application has yet been served. We still haven't received that from Mr. Morgan or his colleagues. So we're prepared to do 28 days after service to respond to that application.
That's a bit long. I mean, I was thinking more in terms of 14, frankly.
Okay. I mean, we can work with 14.
Okay.
If it's when are you proposing to serve the applicant? Sorry, we'd like to ask when the claimants when they're.
I'm going to direct Mr. Morgan to serve the documents on you immediately.
Good. Okay, so that takes us.
I mean, they've been filed with the court, and so it shouldn't present any problem at all for your firm to be given a copy forthwith. That's not a problem, of course, is it, Mr. Morgan?
Not a problem at all, Your Honor.
Not at all. So forthwith, serve docs on HFW.
Could we ask for service of evidence and response on Monday, the 6th of November?
Sorry, your evidence 6th of November, you're saying?
Yes.
Let me just have a look at the calendar on that.
Just over 2 weeks.
Just over 2 weeks. Yes. Forgive me 1 second. Monday 6th, and today we're the 18th. You get a couple, yeah, you get a couple of days extra. Okay. 6th of November it is. So that is on the 6th of November, and that is not midnight on the 6th of November. That's 4 p.m. on the 6th of November.
Of course.
Okay. Mr. Morgan, how long would you like to respond to that? I was thinking of 7 days.
7 days is acceptable, Your Honor.
Okay.
13th.
So 7 days, again, claimant to respond. And I'm going to leave it to the court to liaise with you to fix a hearing before me as soon as possible. After then, that will be Monday the 13th. I'm around in Dubai at that time anyway, but we will try and fix a hearing as soon as possible after that date. In liaison with you, whether you're dealing with it yourselves or instructing counsel is a matter for you, but we'll find a mutually convenient date.
Thank you, Your Honor. Much appreciated.
Okay. Well, is there anything else at the moment that we can deal with?
Your Honor, you mentioned about that you would may possibly be giving directions that this should be dealt with as a Part 7 claim rather than a Part 8 claim.
I will. I'm going to include that in the order. Yes, this will continue as a Part 7 claim on the court's own initiative, which I think I have jurisdiction to do.
And just a question, Your Honor, in communication with counsel for the defendants, they have alleged that they are not prepared to accept service on behalf of the respondents or the defendants. Is counsel now prepared to accept service?
I'm not sure which communication you're referring to, but yes, we are prepared to accept service.
Okay, and you're on the record. You're going to be
on the record, exactly. So there's
okay, yes. Well, then those are problems that we have disappeared.
Yes,
if they ever were problems.
The final point, Your Honour, is Mr. Morgan doesn't appear to be a Part 2 registered practitioner on the Register of Practitioners. I wonder whether he is in the process, perhaps, of being.
Well, I'm sure he will fix that. Otherwise, he's going to find himself in a very embarrassing position.
Very much, Your Honour. It's in the process right now.
Okay.
With the court's relevant department.
Thank you. Okay. Well, I'm sure we'll get that administrative issue dealt with as quickly as possible.
Thank you, Your Honor.
And anything else, Mr. Morgan, anything else from you?
No, thank you, Your Honor. We are looking forward to, again, this being a Part 7 claim and happy to contest this matter in a hearing.
Okay, Mr. Braganza, anything else?
Nothing from me. Thank you, Your Honor.
Okay, good. Well, we've got things moving, and we have a way forward, and we'll get an order out. But you know now exactly what you've got to do. Okay, and I look forward to seeing you in due course on the hearing of this injunction. Okay. If there's nothing else, I'll wish you all good day. Okay, thank you very much.